Hello, this is Paul Callahan and welcome to our Hot Topics and Trends in UK Employment Law webinar. I'm the head of the Employment Law Group at Taylor Wessing, and I'm going to be joined in this webinar by a number of members of my team, Roxanne Davey, Senior Associate, and two associates, Katie Davenport and Michael Chattel. When we originally scheduled this webinar, we thought it might well be after Brexit, because Brexit was scheduled to take effect on the 31st of October, Halloween. But as you'll know, that didn't happen, and it's now being put off again, if it happens at all, until the 31st of January. So there's, in reality, in relation to Brexit, there's no new news. And what that means is that certainly from an employment law perspective, everything stays the same for now. From an immigration law perspective, if you haven't already, you do need to think about making sure that any non-British EU nationals you have working for you in the UK are properly registered. You actually do have until the end of 2020 to do that, but provided you do that, they will continue to have freedom of movement. After that date, assuming we do Brexit, then freedom of movement will go and there'll be a new points-based system introduced for EU nationals who will effectively be treated the same as any other third-party nationals. But we have a lot of other things to talk about instead, because since we scheduled this webinar, a general election's been called, and so we're going to look at some of the possible employment law changes as a result of the outcome of that election, some of which could be extremely radical. And one thing that has happened in relation to Brexit since our last webinar is that the deal that Boris Johnson started to get through Parliament and then gave up on, but the new deal that he has at least reached with the EU, unlike Theresa May's deal, the new deal doesn't preserve for a transition period any EU employment laws in UK law. So what that means is, theoretically, if we were to Brexit on the 31st of January, very soon afterwards, if they were so inclined, the government could start repealing the EU employment laws, which include a lot of anti-discrimination laws, a lot of the working time laws that Katie's going to be talking about a bit later, some of the data privacy laws, and the transfer of undertakings laws. Whether that happens or not, we shall find out, and the parties' manifestos for the elections haven't actually been published yet, although we've seen different policies already put out there. And I suspect no party is going to say that they're going to repeal things like discrimination laws, but who knows what will happen if we get a majority government that is committed to the free market and without much restraint. In the meantime, though, we also have some very big changes about to happen in April next year, which, as far as we're aware, will happen whoever wins the general election. And the most important, or at least a very important one to be aware of, are the proposed changes to IR35. IR35 is the system whereby you engage self-employed people through their own private service company and pay them, because they're self-employed, you pay them without deduction of tax because they're self-employed and you don't have to put them on your payroll. That system is going to radically change from April 2020, and Roxanne Davey is about to explain how and what you need to do to prepare.
Hi everyone. So looking at this first slide here, that sets out the background, which is essentially what Paul's just described. So we've got this system in the UK whereby we have a significant amount of individuals that are engaged as contractors providing their services via a personal service company, and that is often abbreviated to PSC. It's largely tax-driven, and as a result it means that a lot of these individuals aren't paid via PAYE in the same way that employees are, and often they receive their income through dividends. So if we look at the current position first, the responsibility for deducting the correct taxes and social security or NIC contributions rests primarily with this PSC, as does the liability for not paying the correct taxes. So if you've got a chain where A is the individual contractor, B is the PSC, and C is the fee-paying client, then at the moment if A would be C's employee but for the fact that they're providing services via B, the PSC, then it's B, the PSC, that has to make sure that it makes the correct deductions for income tax and NICs on the earnings that A earns from C. And currently, C, the client, has got no liability for paying tax and NICs. So we've had some draft legislation published, and as Paul said, we think this is likely to go through whoever wins the election in December. The current proposals are that from the 6th of April 2020, new rules are going to apply, and they're going to reflect the changes that have already been made in the public sector, and they were made back in 2020. These new rules mean that the responsibility for assessing the true status of contractors and deducting income tax and social security or NIC contributions from the fees paid to them is going to now lie with the end user client to whom the contractor provides their services. This means that clients that engage contractors are going to have to determine if the contractor is inside or outside the rules known as IR35. And if they're inside IR35, the client's going to have to operate PAYE on the fees due to the contractor. The liability for not making the correct deductions for income tax and social security payments will generally lie with that end user client. And if that's the case, they'd be liable to pay any overdue tax or NIC contributions, together with interest and penalties on those. In the UK, whilst the test for employment status from a tax and employment rights perspective is quite similar, it's not identical. And so this means it's possible that a contractor could be considered to be an employee for tax purposes, but not necessarily for employment rights purposes. So it's important to note that this isn't automatic, and even if on assessment it's considered that actually some of these contractors providing services via PSCs are employees for tax purposes, it won't necessarily follow that they'll get all the rights and benefits that employees or workers would otherwise get from a rights perspective. So which organisations do the new rules apply to? They're going to be quite far-reaching. So even though they are only deemed to apply to medium and large organisations, and small companies are to be exempt from the changes, the definition of small companies can be quite wide-reaching. So a small company is going to be a company which meets at least two of the following three criteria. So the first is an annual revenue of less than 10.2 million. The second is a balance sheet which is not more than 5 million. And the third is 50 or fewer employees. But what's important to note is that this includes parent companies. So if you've got a UK subsidiary that would meet those thresholds and is small, but the parent company, perhaps in the US or elsewhere, is large or medium, then the UK subsidiary won't be able to be relying on the small company exemption for these purposes, and it means that that UK sub will be caught, and so it will need to run this assessment for any contractors that it's engaging via a PSC. So what should you be doing to prepare? First of all, review the current workforce and your reliance on contractors. So know where in the business they're engaged and what they're doing. 2, assess the current terms and arrangements with contractors to determine if they're likely to be deemed to be inside these new rules or not. So it's important here that when you're carrying out this assessment, you don't just look at the agreement that you've got in place with the contractor, as in the written agreement. You also need to consider how the relationship operates in practice. And here there are several things that you'll need to think about. Examples are, how long have they provided the services for? How regularly do they provide them? Do they have any other clients, or are they economically dependent on this engagement? Is there any minimum term for which they need to provide services? And what type of work are they doing? Is it based on a kind of team output, or are they purely considered to be providing individual effort, and that's the basis on which they're paid? The third point to think about is then any employee and or worker entitlements and benefit obligations that might arise in a result of a change in status determination. So, I mean, as we said, it may be the case that you review them and consider that actually they may be an employee for tax purposes, but you're comfortable that they wouldn't be for employment purposes. Alternatively, the assessment may be that they would be an employee or a worker for both. And if that's the case, you'll have to think about what follows on from that? Would they be entitled to national minimum wage, for example? Would they be entitled to holiday pay, sick pay, and so on? 4 is consider alternative options. So that may be thinking about moving contractors onto employment terms or worker terms or some other kind of engagement. 5 is to educate your HR teams to help them develop the skills and knowledge that they need to conduct this status assessment I've just mentioned when they're engaging new contractors going forward, so that no mistakes are made in the future. And have a look at your paperwork and make sure that all of your employment contracts, worker agreements or consultancy agreements are truly reflecting the status of the individuals that you're engaging. If you've got a particularly large number of contractors, when you're carrying out the assessment as to whether or not they are truly an independent contractor or whether they should be assessed in, you also might, depending on the numbers that you have, want to think about doing this on a role-based basis rather than doing it individually. If you've only got a couple of contractors in your organisation, then an individual approach may be perfectly acceptable. But if you are engaging significant numbers of contractors, it may be much more time efficient to instead kind of think about the roles in which they're engaged and assess their status on a role by role basis. And other things to think about. So if you've got very highly skilled contractors, they may seek to review their pricing structures to reflect the fact that their take-home pay will now be subject to more tax and social security deductions, and ultimately that means it may be more expensive for the client. So consider that ahead of time and think about budgeting and action plans for that. And secondly, and this is really something that you may need to be thinking about at the outset, is on a worst case scenario, if a significant proportion of your consultants were considered to fall within these rules and you did have to make deductions for them, think about what the costs would be to the business, as ultimately that might inform all of your kind of plans and next steps going forward, depending on how significant those costs might be.
Okay, and I think one really important point to be aware of is that if you do think, having done this test, that you have contractors who come within the new rules, and you do have to write to them and notify them, and they also have a right to object to your finding. So there is a bit of a process to go through, as is often the case with UK employment law. So thanks, Roxanne, for that. That is something extremely important, and we have created flowcharts to help you if you do have contractors in the UK, and if that might be relevant. Now handing over to Michael Chattel, who's going to talk a bit about how GDPR is evolving in the employment law context now that it's been enforced for a while, and the really significant uptick in subject access requests from both existing employees and former employees, and what sort of stance the regulator, the Information Commissioner's Office, is taking in relation to those. So over to you, Michael.
Thanks, Paul, and hi everyone. So as Paul said, it's been 18 months now since the GDPR came into force, so I thought it would be useful to provide an update on what we've seen change since then, how we've seen GDPR evolve in practice, and what trends we've seen in our experience. So, firstly, it is obvious that the difficulties of implementation of GDPR relating to employee data anyway has not been confined to just last May when GDPR came into force, and it is still something that employers are struggling with across a full spectrum. So many employers did choose to implement GDPR fully ahead of or shortly after last May. And those employers do often find themselves now in a good position, just updating or tweaking their policies and procedures as needed. But there are many others that either chose to implement just some measures at the time, but chose to limit those to very quite isolated areas, either for expediency or speed. And then there are some that are still getting to grips with GDPR and perhaps have put in place very little or no meaningful compliance measures. And really the message is for those in the latter two categories, this approach was often seen at the time last year as fairly low risk in the short term, because at the time everyone was really getting their head around what GDPR was, and the regulator, the ICO, was likely to show more flexibility and give employers a bit more time to put in place the necessary measures. But we are now at a stage where 18 months in, the ICO, that degree of flexibility the ICO will be showing is diminishing, if not gone. And so they will be expecting, if they do look at an employer, they will be expecting to see compliance measures such as processing records, retention policies, and evidence of a data analysis having been carried out. So the further we get away from the implementation of GDPR, the more likely it is that data issues are going to arise, and so not being fully compliant is something that's becoming more and more risky for employers, and therefore it is important that this is an issue that is taken seriously, and that any remaining or new steps that need to be taken are carried out as a priority. And even for those that did carry out, put in place full measures at the time or since then, it is important to be regularly reviewing this issue and making sure that what is in place is sufficient, and to really evidence ongoing compliance if you are challenged by anyone on this. But even 18 months on, there are some areas that remain unclear and problematic around GDPR. Really, the main one I wanted to flag here was around criminal records checks. In our experience, this is an area where many employers have had issues with balancing commercial needs, often driven by underlying clients, with the company's GDPR obligations. And this is something especially true often for North American-based companies, where regular criminal records or other background checks are more common. But generally, the position in the UK is that these checks should only be carried out where it's necessary and justifiable under the GDPR legislation, and often where consent can be gained. So if this is something that your company does carry out in the UK, we do recommend it's something that is given specific thought and advice is sought on it, because it is a complex area, and applying a blanket policy often doesn't work and does raise the risk of a breach of GDPR. So one of the purposes of the GDPR was to force a culture shift amongst individuals and companies towards their use of data, and how data privacy as an issue was perceived. So the early signs that we're seeing is this is succeeding to an extent, and we are seeing an increased awareness and focus on data rights amongst employees. They are increasingly becoming aware of and really taking action around their data privacy rights. So this means that, firstly, the employees are more likely to question what compliance steps the company has taken, and we are seeing that more and more. So really, this reinforces what I was saying about previously about ensuring that you are up to date and fully compliant in terms of your implementation of GDPR. But more tangibly, this increased awareness amongst employees is manifesting itself in the increase of data subject access requests. As a reminder for anyone not aware, a data subject access request is a request that all individuals in the UK and across the EU are entitled to make under GDPR to see what personal data an employer or any other company holds about them. Now, this isn't a new right under GDPR. It was something that did exist under previous UK data protection law, but really this increased awareness by the employees and the changes that GDPR has made has really brought this right that the employees have to the forefront. And so we are seeing a quite significant increase in the amount of data subject access requests that are being brought by employees. And these are being brought in two contexts really. So the firstly is litigation. Now this was historically where most data subject access requests were made. But again, as I said, the increased awareness is just only increasing their use in this context. So the purposes of the data subject access requests is technically to monitor a company's data use and retention and allow the individuals to ensure that to find out what data is being gathered on them and how it's being processed. But inevitably, they are being used as a tactic in litigation to extract early disclosure, such as discovery, out of employers, either as a precursor to litigation or in the early stages of litigation. And they're also being used by employees to really create extra work for employers in the context of litigation and to put pressure on them, often with a view to try and extract a settlement out of them. But then wider than just a purely litigation context, we are seeing more and more just general requests, so general data subject access requests from employees. So employees are increasingly using this tool to extract specific pieces of information from their employer. Usually this is where a decision's been made that they didn't like, for example around promotion, a disciplinary or pay review, while previously often they would have just had to live with what the information they were given by the employer. This awareness of this right that employees have means that they are more and more bringing these formal requests in order to gather certain bits of information held about them, including emails and other data. Unfortunately, this isn't something that employers can avoid, and unfortunately it is something that we are only going to be probably seeing more of as it becomes more and more of a common tool that's used. And awareness only continues to grow. So it is very important that employers are prepared to receive one. So this includes training for employees in how to recognise one, and really having efficient and established procedures and policies in place so that when you do receive one, you know exactly how to deal with it. As you'll probably know, the deadline for complying with data subject access requests was reduced to 30 days under the Gdpr, so employers can rarely afford the delays in responding to these. So you really need to be ready to deal with one as soon as it comes in and know exactly who's doing what and what they have to do in order to comply with their obligations. And this will include knowing what your actual obligations under the GDPR are around data subject access requests, and knowing where you can push back on requests, both around the request itself and the scope of its request, to make sure that you're keeping the work that you have to do to a minimum and not giving them unnecessary amount of information. So having these steps in place is increasingly important. As Paul said, we have seen a change in the approach that the regulator, the ICO, have taken. So previously, when the GDPR first came into force, the ICO was more concerned with really the big ticket issues in companies such as Facebook, Google, etc. And we did see some substantial action around those big data breaches and some substantial fines. So, for example, British Airways were fined 183 million earlier, so in June of this year. But the ICO hadn't previously shown a particular inclination to investigate individual complaints around issues such as data subject access responses. But this, in our experience, is starting to change, and anecdotally we have heard that the ICO have hired a lot of junior employees to start investigating these kind of issues, and so they have actively started to investigate one-off complaints by employees and starting to probe what steps companies have taken to comply with their obligations around things like data subject access requests. We've already dealt with a few cases where we've had to interact with the ICO and explain and justify the responses that companies have given to data subject access requests. So far, these, in our experience, these investigations have been relatively unsophisticated, and we are yet to see any fines levied for non-compliance on an issue such as this. But really, it shows the direction of travel that the ICO are taking. So it is more and more important that employers are ensuring that they are ready to comply with their obligations, and they do comply with them, and to be able to show clear evidence of doing this in case they are questioned by the ICO. So the final point to cover is just on a developing issue that employers are facing around data privacy, and that's of vicarious liability for the actions of their employees regarding data breaches and data privacy. So the main ongoing case that's really driving this issue at the moment is that of Morrison's, which is a UK supermarket. Back in 2015, a Morrison's employee who was unhappy about some disciplinary action taken against him by the company took it upon himself to publish the sensitive personal data of around 100,000 Morrison's employees online and send them to various UK newspapers. Now, the employee was convicted of various crimes relating to this, but as a separate issue to this, about 9,000 affected employees of Morrison's have brought a claim against the supermarket for compensation in relation to this breach. Now, importantly for employers, both the UK High Court and Court of Appeal have found that Morrison's were vicariously liable for the actions of this employee, even though they did have in place certain policies and steps and really had done nearly as all they could in terms of preventing this. Now, there are some outstanding issues around this, and the case was heard at the Supreme Court last week, but we're still waiting for a judgment on this. But if the decisions of the High Court and the Court of Appeal are upheld, it will be fairly significant for employers, as it will introduce another element of risk around risk of liability around data privacy. So this is an area definitely to keep an eye on, and really the main point to take away is that employers should ensure that they have safeguards in place to protect themselves against employees going rogue, and also potentially consider taking out insurance against a risk such as this, because as I mentioned, Morrison's did have in place a number of safeguarding policies and procedures and really were considered to have done all they can, but nonetheless, so far they have been held liable for the actions of their employee. So really the message we wanted to get across is that GDPR compliance shouldn't be something that should be considered as something that has come and gone last May when it came into force. And it is an ongoing risk for companies and an ongoing compliance issue that really needs to remain a priority for companies when dealing with their employees' data.
Great, thanks, Michael. And as listeners may well know, fines for breaches of GDPR are up to 4% of global revenue, so they are potentially huge, even if we haven't, and we have seen some very big fines for data breaches, albeit not yet in relation to subject access requests. But as Michael said, it is becoming increasingly common that we're having to deal effectively with twin tracks. So there's employment litigation on the one hand, and then there's correspondence and demands for information from the Information Commissioner on the other hand, as disgruntled employees or former employees are making complaints to both the Employment Tribunal and the GDPR regulator. Now we move on to Katie Davenport, who is going to talk about working time, because there have been a number of recent cases in relation to working time that you really need to be aware of.
Thanks, Paul. So to start with, an overview of how we've got to where we are in the UK as regards working time. Working time in the UK is overseen by the working time regulations, which were brought in 1998, so quite a while ago, to enact the EU-wide Working Time Directive. The purpose of the working time regulations are to effectively ensure the health and safety of employees. So that's an idea that's quite distinct and perhaps unusual to other jurisdictions, is that EU sees holidays, rest breaks and time off as a matter of health and safety for employees. And so in the UK, non-compliance with working time regulations can be enforced by both the courts and the health and safety executive. The working time regulations protect workers, and that's quite a broad definition. So it's anybody working either under a contract of employment or any other contract whereby they undertake to perform personally any work or services for the other party to the contract, and where the other party is not a client or the customer. So in other words, it's the same test as for a lot of worker status issues at the moment. So it's separate to the one that Roxanne discussed about tax, but the other worker status tests for all intents and purposes. And to that end, working time has been included, or is a factor of a lot of the worker status debates that's going on at the moment, because it's something that, as we'll get on to, has an impact on the flexibility of the workforce and the time in which you can ask them to work. It also applies to agency workers, slightly more complicated because it requires a review of who actually has control of the worker and whether they fall into the definition of worker for the purposes of the legislation. And if they don't, the person who pays them will be the one that's responsible for compliance with the working time regulations. There are some exclusions to compliance, but they're quite specific and unique. For example, mobile aviation workers or mobile maritime workers, so really not that applicable in the modern day workforce. And there are some workers that are part excluded, but again, quite unique. For example, domestic staff, police and emergency service workers, or potentially junior doctors. Moving on to what actually is working time. So under the legislation, it's defined as any period in which the worker is working, carrying out their duties, and at the employer's disposal. All three criteria must be met for time to be considered working time. It also includes any period of relevant training, which means training for employment, work experience provided pursuant to a training course or programme, or both. And it also includes any additional period agreed in a relevant agreement to be working time. So that can be in a contract of employment, a collective agreement, or a workforce agreement. So anything specific that you've got in there about working hours will apply in this instance. So looking into this a bit further, what is included in working time? So overtime is, unless it's something purely voluntary, which the employee has gone off on a whim of their own to work longer, then overtime is included. More common with hourly paid staff than salaried, but it could still be a consideration. Any time spent on call is included, so unless they're free at home to do what they want, except for being at the employer's call, then any other time spent on call is included in working time. Travel time where travel is part of the job, for example, sales reps driving to and from different clients, that will be included as working time. Working lunches and also work-related training are included. And so moving on to what isn't included. So rest breaks, which we'll explore a bit further later on, but including lunch breaks and coffee breaks, are not included. They're separate to working time and counted as break time. Annual leave, daily and weekly rest periods, which again we'll cover in a few slides. Travelling to and from work where the workplace is fixed is not included, so that's expected of the employee to do in their own time. And work-related social events are not included for the purposes of working time. So a refresher of what the rules are for working time. These are nothing new. They've been in place since the regulations came in 1998, but are something that aren't always taken into consideration or can quite easily get forgotten about in fast-paced industries. So, rule number 1, the employee shouldn't be working more than 48 hours per week unless there's a written opt-out in place. So, under the regulations, the employer needs to demonstrate that they have taken all reasonable steps in keeping with the need to protect workers' health and safety to ensure that each worker's average working time does not exceed 48 hours per week. So this is taken across a 17-week reference period, so it's not something that would be breached if an employee has a particularly busy week one week and works over 48 hours, but generally works less than that. It's if over 17 weeks they're consistently averaging over 48 hours. Obviously, the big caveat here is employees can opt out of this, and it's quite common to see, either in the contract of employment or as a separate letter when they join, a written opt-out, which is a defence to non-compliance. But it's a point to note that it's actually still a common law duty to ensure and protect the health and safety of workers. So just having in place an opt-out will not automatically allow an employer to ask their employees to work all hours of the day, if it poses a reasonably foreseeable risk to their health and safety. And the opt-out should specifically state that the worker agrees to disapply the limit, and it can also be cancelable on either 7 days' notice or a longer period if that's in the contract. For example, it's quite common to see that they can retract their opt-out in 3 months. Also to note on the opt-out that trade unions and a lot of worker groups have criticised the kind of automatic inclusion of an opt-out either in the contract of employment or as part of an offer pack, but it is still something that we see quite commonly. Moving on to rest periods. So the regulations stipulate that employees should have 11 hours uninterrupted rest per day, and either 24 hours uninterrupted rest per week or 48 hours uninterrupted rest per fortnight. Again, this is more relevant for shift workers or hourly paid employees who might be working Monday to Sunday. And then also the key one which is always included in the employment contract is the break of at least 20 minutes if the employee works over 6 hours in a day. This break can be unpaid, and it's quite common to see longer than 20 minutes allowed, for example, an hour and an hour's unpaid lunch break. There's also the requirement to allow at least 5.6 weeks paid holiday, so that equates to 20 days plus the 8 public bank holidays in the UK for a full-time worker. So 8 public holidays in England to specify. And there's also special rules for night workers under the working time regulations, but less applicable for kind of the tech industry, but potentially applicable for anybody that's got workers working at least 3 hours during the night time, which is counted as 11 p.m. till 6 a.m. And finally, the employer must keep records. So this, in the UK at the moment, means that they need to show compliance with the 48-hour working week for non-opted out employees, and that night work limits have been complied with. So that's all that's required to keep records of for the time being, but we'll move on to what might change in this shortly. So moving on to a recent case, I won't try and pronounce the Spanish name, but this was a European Court of Justice case, so it's applicable throughout the EU, in relation to the Spanish branch of Deutsche Bank. So this was a group action brought by trade unions who were aiming to obtain a declaration of the existence of an obligation on Deutsche Bank to set up a system which records the actual number of hours worked daily and makes it possible to check compliance with the Working Time Directive limits. So a declaration is something that the ECJ can give out in relation to an EU-wide law, which is what they were seeking. Just looking at the facts briefly, Deutsche Bank had in place a computer application, which was kind of an absences calendar, which enabled exclusively holiday absences to be recorded, such as holidays or other leave, but without measuring the duration of time worked by each worker and the number of hours of overtime worked. So the trade union raised issues in respect of the provision for minimum periods of daily rest and of the weekly rest, as well as the upper limit of 48 hours for the average working time in a 7-day period, including overtime. So the ECJ held that in order to ensure the effectiveness of the rights provided for in the Working Time Directive, the member states and employers are obliged to introduce an objective, reliable and accessible system which enables the duration of working time worked each day by each worker to be measured. So as I mentioned previously, the current UK legislation position is that employers must keep and maintain records which, broadly speaking, adequately show that working time, including overtime, for all workers who have not opted out does not exceed 48 hours per week, and also that the limits on night work have been complied with. So obviously the ECJ's declaration is broader
and goes much further than the UK legislation at the moment. So there's an argument that our current position in the UK and the compliance with it is incompatible with the Working Time Directive. So previously, employers in the UK have been keeping records, for example, of pay, or the monthly payroll, and have been using those to ensure compliance with the 48-hour working limit for non-opted out employees. But this case means that going forward, the courts and the Health and Safety Executive might decide that these aren't good enough and that we actually need more detailed records to be kept. There's also potential for the government to look to amend the working time regulations to comply with what the ECJ has said the Working Time Directive means. But again, this, as with most things in the UK at the moment, has a big question mark about Brexit and the enforceability and applicability of EU-wide legislation and the ECJ's rulings following Brexit. Nevertheless, it's good practice to keep clear records of hours worked by employees, because it's the easiest way to defend a claim brought by either the employee or the Health and Safety Executive regarding working time limits and rest breaks. Finally, moving on, we've got one more case to discuss, the East of England Ambulance Trust and Flowers. So this is a UK case regarding overtime and holiday pay. So holiday pay, if you've had the pleasure of trying to look at it for your UK employees, is notoriously complex, and to be honest, there's not really a consensus on exactly how it should be calculated properly. But this looked at holiday pay in respect of overtime. So previous case law has established that holiday pay must correspond to the normal remuneration so that employees aren't discouraged from taking annual leave, going back to the idea that annual leave is for health and safety. So it's always been, previous case law has decided that guaranteed overtime is definitely payable, holiday pay is definitely payable on guaranteed overtime. So in this case, the claimants who worked for the ambulance trust did a fair amount of voluntary overtime. So it wasn't included in their contract, but it was necessary in order to fulfil their role properly. And it was held that voluntary overtime in the preceding 3-month reference period should be paid on holiday pay. So that meant an increase in holiday pay based on the extra hours that they'd worked, even though they weren't contractually obliged to do so. The court focused on the fact that the voluntary overtime was regular, and regularity is quite a difficult concept to define in this instance, but there needs to be a sufficient pattern. But again, a slightly grey area into how often this needs to be in order to pay holiday pay on this overtime. And so they're the two kind of standout cases from recent months with regard to working time. But again, watch this space in terms of what, if anything, has changed in the working time regulations with Brexit and elections coming up.
Great, thanks, Katie. And so now we're going to look, our final topic is to look at the election and what we know so far about possible employment law changes that might come following the election. The election is on Thursday, the 12th of December. We've got very contrasting either proposals or ideas from the two major parties. Boris Johnson has written in the past that he approves of the US system of at-will employment, so effectively the abolition of any unfair dismissal rights, but he hasn't said anything so far about that. A lot of his cabinet colleagues wrote chapters in a book called Britannia Unchanged, where there was a lot of advocacy for wholesale repeal of regulation, including employment laws. On the other hand, Jeremy Corbyn has talked about introducing a ministry for enforcing employment rights, and so if he were to be Prime Minister, we could expect to see a pretty significant increase in employment protection in the UK. So Roxanne is just going to talk us through what we know so far.
Thanks, Paul. So, as Paul said, the general election's on the 12th of December, so that's just a little over 4 weeks away. The main political parties haven't yet released their official manifestos, but they have, over recent weeks and months, been releasing some proposals and some pointers towards what some of their key policies may be. So not on the slide, but a common theme across all of the political parties has been in relation to national minimum wage and national living wage. They're proposing various ideas and ways of dealing with it, but the general theme seems to be to increase it, though by how much and how quickly is something that varies across the board. So on the slide there, you've got the key kind of employment-based proposals from each party, as we know them at the moment. And I'll quickly run through some of the ones that are most likely to have a significant impact on employers. It's not on the slide, but today we've had a lot in the press about Labour's proposal for a 4-day or a 32-hour working week to be implemented in the next 10 years. And as you might have seen, there's been lots in the press about whether or not that would apply across the board to all types of employee, and particularly those in the NHS or otherwise. Labour's also considering offering maternity pay for a full year. At the moment, statutory maternity pay is currently paid for 39 weeks, with the first 6 weeks at 90% of earnings, and usually the last 33 weeks paid at approximately £149 a week. And Labour's proposal is to extend that lower payment for another 3 months, so the pay is for the full year. Labour are also proposing to increase the right to work flexibly so that it applies to all workers. So you might know that at the moment that right only applies to employees in the UK, and notably that's a right to request and not an automatic right to be granted the opportunity to work flexibly. They're also proposing a new workers' protection agency that could fine companies that don't report or tackle their gender pay gaps. And finally, they're proposing that large employers, so that's employers with 250 employees or more, might need to put in place a workplace menopause policy to break the stigma associated with individuals going through the menopause at work. For Conservatives, aside from the issues that Paul mentioned, one of the key things that they've mentioned in relation to employment more recently has been the introduction of a pensions dashboard, and that's aimed at enabling individuals to be able to log on to one place and understand, what type of pension they have, who manages it, and how much it's worth. And then the Liberal Democrats, one of the biggest elements of their manifesto from an employment perspective is in relation to family leave, and that's largely driven by encouraging men to also spend more time at home caring for children, particularly when children are born. And they propose to do that by introducing several new elements of legislation. So one is to require large companies to publish their parental leave policies. 2 is to extend shared parental leave to self-employed fathers, as at the moment it's only eligible for those that are employed, and also to grant it from day one, so there's no minimum service requirement. And finally, to increase paternity leave from 2 weeks to 4 weeks. So at the moment, paternity leave is paid at the lower rate of SMP, so that's approximately £149 per week for 2 weeks, and they're proposing that that's increased to 4. And they, similarly to Labour, are proposing that companies with over 250 employees are required to monitor and publish data both on diversity in employment and also in relation to their pay gap. So as I said, we're still awaiting the manifestos, so none of this is set in stone just yet, but this should give us an idea as to what the parties have in mind.
Great, thanks Roxanne. We don't have time really to take questions right now, but we will be sending everybody who's registered for this webinar all of the slides together with a team sheet which will have the email addresses for everyone who's been speaking. So if you don't already have our details, do feel free to email with any questions on anything we've talked about or any other angle or query regarding UK employment law at any time. So thank you for listening. I hope you found that helpful. If you do have any suggestions of other topics you'd be interested in hearing about for our next webinar, do get in touch. And I suspect our next webinar again might be provisionally about Brexit, and let's see whether it's happened by then. So thank you again for listening, and I hope you enjoy the rest of your day.